Good afternoon, everybody. Welcome. I'm Rick Hasen of UCLA Law and the Safeguarding Democracy Project. I'm very pleased to welcome you to today's webinar, Can and Will Courts Ensure Free and Fair Elections in 2026? It's kind of a sequel to our last webinar, Myths and Facts about contesting the 2026 midterm elections. Today, we will be hearing from three experts in the field. And before I introduce them, I want to tell you about our last upcoming webinar of the semester. That one is going to take place on Thursday, April 23rd at 12:15 Pacific time. That one is the State of American Democracy in 2026, kind of a big picture look at where we've been over the last year. We'll be joined by Michael Kang of Northwestern, Lisa Mannheim of the University of Washington, and Fernita Tolson of USC. You can register for that webinar at safeguardingdemocracyproject.org, where you will also find links to recordings of all of our past programs, including this one. Let me thank Ben Austin DeCampo and Harley Ham for their logistical support today. And Ben will be adding into the chat information if you are trying to get continuing education credit in California. He will let you know how you can do that. If you have questions for our panelists, please use the Q&A function. If you're watching this live on Zoom, at the bottom of your screen, you should find that somewhere buried in all of the things that you can do now with Zoom. All right, so I'm very pleased today to welcome our three panelists for today's program. And we will start with introducing them in alphabetical order. Lori Ringhand teaches courses on constitutional law and election law. She's been a member of the University of Georgia School of Law faculty since 2008. She is the author of a brand new book, which is coming out this month from Stanford University Press, which am I remembering the title right? It's not here in your bio. We the Voters, I do have it. Constitutional Choices That Shape America's Elections.
Yes.
Yes, great. Miriam Seifter is the Richard E. Johnson Bascom Professor of Law, H.I. Rome's Fellow, and co-director of the State Democracy Research Initiative at the University of Wisconsin Law School. Her research addresses questions of state and federal public law with a focus on the challenge facing democracy at the state level. And Stephen Vladeck is professor of law at the Georgetown University Law Center. He's a nationally recognized expert on the federal courts, the Supreme Court, national security law, and military justice. He is the author of a great book, which I think has recently come out in paperback, the Shadow Docket, which I recommend to you. He's at work on a new book as well, which I am looking forward to. Welcome to all of you. Thank you for being here today. The role of the courts is in the news. Just yesterday, we got unsealed some search warrants related to the seizing of ballots by a sheriff in Riverside County, California, indicating that courts are going to play a crucial role in how election integrity is going to be protected in the 2026 midterm elections. And so I've asked each of the three panelists to kind of put all of this in context to give us a perspective. We're going to start with Miriam. We're going to start with Miriam talking about the role of state courts. Lori turning to the connection between state and federal courts with some information about the recent seizure of ballots in Fulton County, Georgia, and then Steve Vladeck focusing on the Supreme Court. And then we'll open up to discussion. If you have questions, again, put them in the Q&A box and we will try to get to them. And with that, let me turn it over to Miriam.
Great. Thank you so much for having me today. So as Rick indicated, I will focus on the role and the record of state courts in assuring free and fair elections. And let's start with their role. So what should you know about what state courts do in connection with elections? I'll give you 4 points to think about. The first and biggest picture point is this. State courts are the go-to courts for most ordinary election administration conflicts. That's because states and local governments run elections in this country. So as a result, many, maybe the bulk of election administration issues will be questions of state law that will typically be decided in state court under state statutes or state constitutions. That's true in the run-up to elections on issues like whether voters can use drop boxes and where they can vote. And it's true in the aftermath of elections. We're starting to hear a lot of speculation or worry about what will happen with the House of Representatives. But note that even before that, states play the crucial role in getting votes counted and certified. And those are issues of state law that would be decided in state court. Second point about the state court role, state courts also decide adjacent state law questions that can have major effects on elections. In particular, they decide administrative law and separation of powers questions that shape who is in charge of elections and what those officials can do. So, for example, what kind of control must the North Carolina governor have over that state's election board? Or does the Wisconsin Election Commission have authority to promulgate binding guidance regarding statewide election practices? Or do certain rules issued by the Georgia State Elections Board violate the state constitution's non-delegation doctrine? Answer to that question was yes. These are all the kinds of election law adjacent questions that come to state courts that might be easy to overlook, but that can make a big difference. A third important role of state courts is their power to protect voting rights beyond the federal floor. Litigants are increasingly looking to state courts to shore up voting rights where federal law protection is receding or unclear. So, for example, many state courts have been willing to move away from the now weak federal standard known as Anderson-Burdick that applies to election burden issues. And a quick example of that comes from the Montana Supreme Court's 2024 decision in Montana Democratic Party versus Jacobson. It was a case that struck down laws that imposed new restrictions on voting, including removing student ID cards from the list of acceptable primary voter IDs and also eliminating election day voter registration. And the court expressly declined to adopt the Anderson-Burdick standard. It said the Montana Constitution affords greater protection of voting rights than does the U.S. Constitution, and it reasoned that Montana really needed to craft its own state constitution-centric framework for evaluating burdens on the right to vote. This kind of reasoning is consistent with the democracy principle or the state constitutional commitment to democracy. Of course, not every state has decided voting rights cases in that way, but many have. Now, a fourth and final point about the role of state courts gets to something that Rick mentioned at the outset, which is that the escalating battles over elections today may force state courts into new roles that are less familiar to them. So state courts are accustomed to resolving challenges to voting laws and to handling recounts, but are they used to reviewing warrants for criminal investigations into election results with requests to seize ballots? We saw that in Fulton County in federal court, and now most recently we're seeing it in California in state court in Riverside County. The Riverside County Sheriff, as many of you may know, a gubernatorial candidate, has launched a criminal investigation into the state's November 2025 election. And crucially, the investigation has been enabled by a warrant the sheriff was able to obtain from a state court, a Superior Court judge in Riverside County, despite dubious public statements, and we now see from the recently unsealed warrants extremely thin evidence that there was any criminal wrongdoing. Now, the California Supreme Court has just recently ordered the sheriff to pause his probe and preserve the ballots, but it points to a near-term need, which is to try to get ahead of some of these more unusual issues and provide state court judges with resources and legal education that they need to properly evaluate unusual demands. So very quickly, these high points about the state court role, again, they decide bread and butter cases about election administration. They also decide adjacent institutional and separation of powers cases that you shouldn't sleep on because they can make a big difference. They are free to be more protective of voting rights than federal law is, and they often, sometimes are. And they need to be ready in 2026 for unconventional kinds of disputes. Now, more briefly, let me just say a little bit about their record to date in ensuring free and fair elections. Two good measures of state court performance are one, whether they've gotten the law generally right. So in other words, whether they've been sound on substance. And then second, whether they've handled disputes in a way that fosters certainty about the law. So whether they've been helpful on process. So how have state courts done along these metrics? State courts have generally been sound on substance, both pre and post-election. Their record on the whole seems to me at least as good as federal courts. They have, for example, generally avoided conspiracy theories or very obviously political outcomes. As I noted before, they've typically recognized that they can protect voting rights more than federal courts do. And post-election, state courts have had a very good substantive record coming out of 2020 and 2024, with the glaring exception of North Carolina, which I take it maybe Lori will speak to a little bit. But many other state courts rejected baseless efforts to overturn election results and displayed, sound command of the law, reaching plausible interpretations of their own statutes and rules, and very rarely reflecting anything that looked like bad faith. There are, occasionally some exceptions. In addition to the North Carolina debacle, there was an Ohio Supreme Court ruling upholding a deeply misleading ballot measure on gerrymandering that was disgraceful. But those are exceptions to an overall very positive record. I would say a caveat to that is that state courts have maybe not fully been put to the test on substance. There has not been an overwhelmingly close, extremely major race that came to them recently, where they would be under enormous pressure to decide it in a particular way. So there is a little bit of unknown about how they'd perform, but I would say that the record they have built creates a very good indication for following and upholding the law. And then finally, the state court record on process. State courts have performed well, but maybe could still do better. And that's because one ideal for state courts in the run-up to elections is to foster certainty about the process and its requirements. So in an ideal scenario, state courts would swiftly and clearly reject specious, harassing, or nefarious lawsuits, and they'd issue clear decisions about the rules of the road to ensure predictability in the process and confidence in the outcomes. But I think too often we see election cases linger for quite a long time in state courts. There's a long-running saga, for example, in Pennsylvania over the dates on mail-in ballot declarations that's been simmering since 2024. I could give you a number of examples from other states. And, sometimes this is not the fault of state courts at all because they can only decide the issues in a way that has been brought to them and briefed to them. But it might be the case that sometimes state court judges are hoping or waiting for some other actor, like a federal court or a different official, to act first. And I would say that if we really want to have clarity and certainty around elections and to deter mischief, it could be helpful to have state courts take a more prompt and decisive role. And I would make a similar point regarding process post-election. Most state courts have a timeline for filing election contests, but not a deadline for completing them. So if we want to avoid another North Carolina, state courts could consider using their inherent or supervisory authority to set deadlines for election contests in advance. My colleague at SDRI, Derek Klinger, has a forthcoming paper on that issue. But I would say, just to wrap up, in sum, state courts have a strong, albeit imperfect, record in protecting free and fair elections, both in substance and in process, both pre-election and post-election. And it's a record that's likely to be put to the test this year. Thanks.
Oh, you packed a lot in there. Thank you. I've got a number of follow-up questions, but I'm going to hold them for now till we hear from our other panelists. One of the issues that often arises is where is someone going to raise an election issue? Is it going to be in state court or federal court or both? And that creates all kinds of complications. Lori, you're going to address some of that.
Yeah, so Miriam, thank you. That really sets the table because here in Georgia, we have become kind of the one of the centers of a lot of elections disputes, and we have two very active live disputes going on right now, one of which is in federal court and one of which is in state court. So they really juxtapose nicely with what you were talking about the types of cases that are heard and the types of process that are involved in both of these. So I'm going to talk about those two cases, the Fulton County ballot seizure, and then a dispute going on between the, again, Fulton County Commission, which is essentially the county board, the elected county board, and the GOP in that county. And then I'll close by introducing a pending brewing conflict that I think is going to mix up a lot of these lines about who's deciding what. So starting with the Fulton County ballot dispute, most of your listeners are probably familiar with the outlines of this, but it is now kind of deep into litigation. And this is in federal court, just to refresh your recollection of the background facts here, what's happened. This, talking about disputes that linger, this officially goes back to 2020, of course, and the very hotly contested elections here. Fulton County is, of course, Atlanta. It's where the city of Atlanta is, and the various election disputes that came out of the Fulton County count. So what happened, of course, is at the end of January, the FBI executed a warrant to seize the election-related materials from 2020 from Fulton County. They took about 600 boxes of material, including, of course, the actual ballots, the ballots that were cast in that election. And when the search warrant, when the affidavit justifying the search warrant was ultimately released a bit later, it raised a lot of concern as Rick was saying in relation to the recent search and warrant in California. The warrant really was kind of just this collection of things that Fulton County had admitted as errors and explained, things that happened but had very benign explanations that people perceived something that was actually happening but misunderstood or misframed what it meant. And then things that were just truly just conspiracy theories, things that just hadn't happened at all. And what was most troubling, perhaps, in the affidavit was there was no real accusation with any specificity of criminal activity. The closest that the affidavit came to alleging an actual crime was to say, essentially, if any of these things had been done intentionally, then it would be criminal. And the magistrate judge issued the warrant on the strength of that affidavit, and the FBI and the DOJ now have custody of all of these ballots. Well, Fulton County is sued, and Fulton County is sued in federal court to try to get these ballots back into Fulton County custody. And the challenge that they're facing, because there's no trial, there's no actual named person who is a target of any criminal investigation or criminal prosecution here. So there's no easy way to get right at the probable cause question. So the Fulton County is in federal court, and what they are having to demonstrate to try to get the ballots back is under the rules of federal criminal procedure. And it's a 41G motion. And what Fulton County has to demonstrate is that the person swearing the affidavit had acted with callous disregard for the rights of the county. And that's turning out to be a very difficult hurdle to clear. And the federal judge who is hearing the case has had a couple of hearings and some motion action. And where we're at right now is that the current status is the DOJ, Fulton County has put a list of questions to the DOJ about the timing of the decision to initiate a criminal investigation, because one of the things that the federal judge had indicated might demonstrate callous disregard if proven, is that the criminal investigation was a pretext. DOJ, the dispute over trying to get custody of these Fulton County ballots has been going on for years. It started with some GOP members of the elections board. They were unsuccessful. They reached out to DOJ. DOJ initiated a civil action. That has been stymied and has been unsuccessful. And now the criminal action has happened. So Judge Boulay has indicated that if it is pretextual, that might cross the callous disregard threshold, and they are arguing right now about what DOJ has to answer in regard to proving that. So I think this is particularly troubling, especially given what we've seen in California, because it's very difficult to find a way in to challenge these warrants in kind of the near future, in near time. And if a accusation that mistakes, if done intentionally, are criminal, if that can support a warrant justifying seizure of ballots, election officials make mistakes all the time. And I think that could take us down a very rocky path where there's not a clear judicial ability to resolve it quickly in what we're seeing. We've also had a state court litigation, which I'll talk about quickly here, which you may be less familiar with. And this involves the Fulton County Commission, which is statutorily tasked with appointing members of the county elections board. And the way the structure of the elections board works is that each party nominates two individuals for the elections board, and then the chair of the Fulton County Commission nominates an additional individual. That gives Democrats essentially a majority, a 3-2 majority on the board. And the GOP in Fulton County nominated two kind of active election deniers, one individual who had refused to certify election results, another who had taken advantage of Georgia's law that enables individuals to do mass challenges to voter registrations. And the elections board the county commission refused to seat these people. So there was a state court action about whether that task was discretionary or mandatory. That was just resolved last week at the appellate court level, and the court had held that it was discretionary and that discretion had not been abused by the refusal to seat, and the GOP was charged with naming other alternative nominees. We don't know yet if they're going to appeal that to federal court. And then in just a few minutes here, we also have a brewing controversy that I suspect we will hear more of in the near future. The Georgia legislature passed, I think last fall, a law requiring all voting machinery, all votes to be cast on paper. The way Georgia votes right now, depending on your jurisdiction, including in my jurisdiction, we use touch screens. That when you vote on a touch screen, that generates a piece of paper. That paper you look at as a voter, it has a QR code, but it also lists in real text names of who you voted for. You then feed that into a machine. That those paper trails are used to audit. They were used in the statewide recount in 2020 to confirm the numbers. But the new law requires everyone to essentially use Scantrons, bubble sheets. And there was a bipartisan movement in the House to put a delay of 2 years, 2-year delay on that because there was no funding and no real plan to get this done for the midterms. That got through the House. It did not get through the Senate. So as of right now, the state of the law in Georgia is we're supposed to all be using Scantrons in the fall elections, and nobody's really sure how we're going to do that. So I think to the point of state and federal courts, we have a real mix of issues, and the courts, I agree with Miriam. I think our state courts especially, but also our federal court judges here, they're good at being judges. This isn't a deeply politicized judiciary. I'm not sure they have the tools they need right now to deal with some of these conflicts.
Thank you for that. I've got follow-up questions for you too, but let's first turn to Steve. And it's sometimes said, what is the old saw that the Supreme Court is not final because it's right. It's right because it's final. And I wonder here, we know that federal courts those cases can ultimately come up to the Supreme Court. Increasingly, state cases are coming up to the Supreme Court too. And when is it appropriate for the Supreme Court to get involved? And this has come up in a number of election contexts, including recently one involving a redistricting plan in New York. So lots to discuss. Steve, kind of give us the lay of the land, and then we will open it up to a broader discussion.
Sure. So I think the top level point to make before I get into some of the more narrower points is whenever we're talking about the U.S. Supreme Court today, I think it's worth starting from the proposition that this is a court that will intervene at almost any time for almost any reason in any case it wants to intervene in, and is not much constrained by what we might have thought of as the traditional limits, discretionary, normative, equitable, statutory on their authority. I think it might be helpful to break the Supreme Court's role in this conversation into 3 buckets. So the first bucket is merits docket cases that could affect the November election. And by my count, there are 3. There is, of course, the Louisiana redistricting case, where I think most of us, I suspect, expect the court to take the rather stunning step of holding that the Voting Rights Act, insofar as it authorizes majority-minority districts, is unconstitutional in excess of Congress's power. That would be kind of wild. Or at the very least, that the VRA shouldn't be interpreted to authorize it, and that the court was wrong in the 1980s when it held otherwise. The hard question there is, would that ruling come out in time to change the maps in the states that have majority-minority districts? And I suspect I am the fourth most expert person among the four of us to answer that, but probably not, is my gut reaction. That it's probably going to be one of those last rulings of the term, probably the last week of June. And if if the primaries have already been done, or if the primaries are about to happen, I don't know how you can rerun things at the last minute. So that might be a bigger problem for 2028 than 2026. There's also Watson, which is the case about whether federal law, simply by fixing election day as the first Tuesday after the first Monday of November, somehow prevents states from counting ballots that are cast by election day but received within some period of time thereafter. I had thought the Supreme Court had taken this case to smack down the Fifth Circuit. The oral argument was rather to the contrary. I think it's going to be very close. And I think that ruling could very much affect how we vote this November, where in those states that do allow for mail-in ballots to be received after Election Day, I think there's going to be a real onus on folks to make sure they actually vote well in advance of Election Day, or else run into problems. And then there's also the National Republican Senatorial Committee case about the unconstitutionality of the limits on party coordinated expenditures. I suspect that too is heading for the constitutional dustbin, although its effects on the election, I think, will be more at the how many ads we see from whom stage, not the how do we vote stage. Then there's the emergency docket. And hoo boy, this has already been a remarkable term for election-related cases on the emergency docket. The court has had two, I mean, maybe three, but two certainly major emergency docket rulings. The first was in December in Abbott versus Lulac, where the court stayed a three-judge district court's ruling that had found that Texas's re-gerrymandering of its state legislative districts was a race-based gerrymander in violation of the Equal Protection Clause. What's really striking about the Lulac case, and I have a post on my newsletter that Ben just shared with everybody, is just how completely oblivious or even affirmatively indifferent the majority seemed to be to the factual findings made by I hate to say it, but I will, Trump-appointed district judge, right, Judge Brown. It's really striking that a district court who's closest to the ground, who actually took evidence, that actually had an evidentiary hearing, makes all these factual findings about the predominance of race, and the court just waves its hands at it, with Justice Alito writing a short concurring opinion that says, well, there was a legal error somewhere in there, and therefore we don't have to listen to any of the factual findings. If that's going to be a precedent for how the court treats factual findings in election cases going forward, it strikes me as an ominous one, because it gives the court that much more room to get out from under what lower state or federal courts have done. And then speaking of state courts, my sort of nominee for the sort of what I'm looking for, the stealth ruling of the term is Malliotakis. Right, stealth from the perspective of I don't think folks outside of the election law space understand just what the Supreme Court actually did. So going all the way back to 1789, the Congress has distinguished between the Supreme Court's power to review lower federal courts, which is almost plenary and has been since 1925, and its power to review state courts, which has always been much more circumscribed, to the point where there are three different requirements the Supreme Court has read into the relevant statute. The state court's decision must be effectively final on the federal question. There must have been at least some opportunity for review before the highest court of the state in which a decision could be had. And the state court's decision must turn on that question of federal law. There cannot be an adequate or independent state ground supporting the state court's decision. Well, in Malliotakis, the Supreme Court granted emergency relief to block a New York trial court ruling that had ordered the New York Independent Redistricting Commission to redraw the 11th congressional district in New York on the ground that the trial court concluded that it was likely a violation of the New York State Constitution. What is really striking about Malliotakis is not just the preview of Calais that we got from the court thinking that that was clearly a violation of the federal Constitution, but rather the procedural posture, which is that even though the applicants had not properly sought emergency relief from the New York Court of Appeals, the court granted the emergency application anyway. And although there's no majority opinion in Malliotakis, what is really striking about Justice Alito's concurrence is that he comes very close to lying about the procedural posture of the case to make it sound like the New York Court of Appeals actually had an opportunity to grant emergency relief on the merits. There's one sentence in the post that Ben shared online where he actually inverts the order of events without telling you he inverted the order of events to make it seem like the Court of Appeals had ruled after the appellate division. It hadn't. That's a lot of procedural mumbo jumbo just to say what Justice Sotomayor said much more plainly in her dissent, which is it's the first time ever that the Supreme Court had stayed a state trial court ruling without there being at least a pending application for emergency relief in the state Supreme Court. That is striking, and further to Miriam's and Lori's presentations, opens the Supreme Court up to more mischief in cases that start and even end in state courts challenging the upcoming elections, much more than we ever thought was possible before. Then the third bucket, really quickly, is the cases that haven't gotten there yet, which is insofar as we're worried about things like ICE at the polls or troops at the polls. Those seem to be in a different category, and I don't know that we can infer too much from those first two categories about how the Supreme Court would deal with, emergency relief in the context of those. So in a world in which, the president tries to send troops to the polls ahead of Election Day, that's a violation of 3 or 4 different federal criminal statutes that date back to the early part of the 20th century. If lower courts sought to block that, right, would the Supreme Court actually think about staying that? That strikes me as actually not so much implicating the court's election law jurisprudence, since it's not about the rules for elections. And also, I think maybe a place where this court, as sympathetic as it has been to Republicans in election law cases, would not be especially sympathetic to having troops at the polls. ICE at the polls, I think, raises a variant on that question. But I just think it's very hard to predict what would happen in that third category, partly because the Supreme Court has done such a good job of being unpredictable in this space. And it seems to me that, if anything else, is the biggest indictment of the Supreme Court's work in this field, which is that by intervening so often in election and election-related cases, by so seldom writing majority opinions, and by intervening in ways that are very difficult to rationalize by reference to neutral principles of law versus Republicans win and Democrats lose, I think the Supreme Court has made it very difficult for even us, right, the folks who follow this stuff very closely, to be confident about what would happen in that bucket of cases if we get those come October and early November. So on that very optimistic note, I will pass the baton back to Rick.
Thank you. And, one thing you didn't have a chance to talk about much is Moore versus Harper, which is a 2023 case, which makes more state law issues become federal law issues. And those things could arise, for example, in 2020 when in the middle of the pandemic, the Pennsylvania Supreme Court extended the deadline under the state constitution for the receipt of ballots. And then there was a question of whether that violated federal law by abrogating the power of the state legislature, whatever that means. So we do have this big other question mark, I think, out there. One of the themes that I think is common to the presentations that you've all made is that we have this, I think, unprecedented combination of novelty and timing issues. So novelty in terms of like courts are not regularly deciding, state or federal courts are not regularly deciding about seizures of ballots. And timing, federal courts, state courts are pretty slow, even in election cases, to give immediate relief. And so I'd like you each to reflect on kind of how these things interact, and more constructively, maybe, what is it that judges and others should be doing now so that if these less precedented things happen, that people are prepared? Miriam, maybe I'll start with you.
Sure. I think I'll try to answer that in 2 ways. So one is that, states vary on the extent to which they are prepared for emergency election litigation. Some do have expedited dockets and already in place a system of rules to handle those. But if they don't, state courts typically have pretty broad supervisory or inherent authority to set schedules like that. And I think the more that they do that in advance of a concrete dispute, the more neutral and respectable it will look. So that would be a good thing for state courts to be thinking about. The other thing is something that, to follow Steve, I'm probably the 4th most expert person on this panel on, but state courts have actually been pretty good about timing issues in the sense of not lockstepping with the emergence of the so-called Purcell principle as a hard and fast rule that would preclude judicial involvement at a late date. State courts and my colleagues Rob Yablon and Derek Klinger have an essay on this as well. State courts have tended to be more holistic in their evaluation of whether a court should intervene close to an election, and it might depend on the severity of the harm and the diligence of the plaintiffs and the likelihood of actual confusion. But if something arises close in time to an election and it needs an answer, I think state courts actually have a fairly good track record of at least being willing to consider themselves available forums for that. And I think that could be extremely important.
Lori?
Yeah, I agree. I think state courts have a good infrastructure for adjudicating election law disputes fairly quickly. I think the timeline is of less concern to me than their substantive tools, whether they have the right substantive tools available in things like these ballot seizure cases, and in something like the conversion over to Scantron ballots on a timeline that election officials have called just unworkable. It's not even clear to me what that challenge looks like and how that gets in front of a court in a timely manner that might generate some meaningful relief. So I think they can manage the timing. I think especially after the last several election cycles, they have a pretty good grounding in the mechanics of these. I'm not sure they have the substantive tools because the questions are so novel, that intersection of timing and novelty.
Steve, Bush versus Gore, I think from start to finish was like a long weekend. Supreme Court can move quickly when it needs to, but often sits on these things. How do you think the timing issues work in terms of Supreme Court review?
I think this is a very different Supreme Court than the court that decided Bush versus Gore. And in almost no ways that are positive, which is pretty remarkable given the baseline. I think to Lori's point about the state courts and timing, I mean, I think what's really alarming to me is the combination of the rhetoric we heard during the oral argument in Watson and the implications of Malliotakis, right? Which is, the justices are consuming right-wing media. And so what their understanding about what's happening in these cases is coming from Fox News and things further to the right, not from the district court or the state trial court's record. So, that to me is the real concern, which is that the justices will think it's appropriate to intervene in context in which, the Supreme Court intervened in Bush versus Gore, but like went out of its way for years to say that was a once in a lifetime case. I think we're heading toward not even just once an election cycle, multiple times election cycle cases. And part of the problem is that the court is so trigger happy when it comes to emergency relief these days that any kind of sense of equitable restraint is totally gone. And so I worry about the court thinking that in a context where there's novel questions and where litigants are telling them, oh, the state court is doing novel things to harm Republicans. I worry that the court views all of these cases as Bush versus Gore when none of them will be, right? And that's a problem. Even if you think, whatever you think of the court's intervention in Bush versus Gore, right? Even if you almost buy the ground for intervening, if not the outcome, these aren't they.
So let me stick with you for a minute, Steve. So what I'm hearing from you is this current Supreme Court has kind of a lack of forbearance. I have a piece today at MS Now on the three cases you mentioned, Watson, Calais, and NRSC, and comparing it to what the Supreme Court did in 1964 in Reynolds versus Sims, where the court does an earthquake in election law, imposes the one person, one vote rule, causes almost every state legislature have to redistrict. But the court says, but we're not saying it has to happen right now. You can use your equitable powers, lower courts, to just put this on hold till we get to the 1966 elections. And that's pretty much what happened. And so while Reynolds was a big case, it didn't cause immediate pandemonium. It's kind of like the Purcell principle applied to the Supreme Court itself.
Yep.
And I think also like the Boast case, which recently came out, seemed like Chief Justice Roberts was saying, bring these cases earlier rather than later, so we're not jammed up. So I don't know if you can reflect on any of that.
And then there's Alito's concurrence in Malliotakis, right, which says, oh no, we can't possibly, abide the possibility that someone might be elected from a district in a map that was drawn unlawfully. Never mind what happened in Alabama and Georgia and Louisiana and Ohio and South Carolina in 2022. Um, it's the problem here is two things, Rick. It's a lack of forbearance. It's the fact that this court really just feels like it can and should do whatever it wants, whatever it wants. Sort of the most formal articulation of this is Justice Kavanaugh's concurrence last year in CASA, where he talks about how there just ought to be nationally uniform interim answers, and we ought to be the ones providing them, which is problematic enough in the abstract, but all the more so when you realize they didn't actually do that in CASA. So when you mix that with Purcell and with the court's, sort of creation of deeply subjective doctrines that allow it to basically write its way into almost any result, I think it's the forbearance is the first part of the problem. And frankly, I think the second part of the problem is not taking trial court seriously. The trial courts are not perfect. Trial courts make mistakes, but there is a reason why historically trial court fact findings, whether by state courts or by federal courts, are insulated from appellate review except for clear error. And I think, I worry about the sort of the size you can read in piecing together the Alito opinions in Malliotakis and in LULAC of just we can decide what the facts are for ourselves as a basis for intervening when we want. And, yes, that's Alito, not the court, but I worry about where, Justice Kavanaugh is on these questions. I worry about where Justice Barrett is on these questions because, presumably those who think the court shouldn't be intervening are going to need at least one of them to be on the side of not intervening.
Lori.
Yeah, so I had a thought. I saw your piece this morning, Rick, and my thought was we're not just in a different legal environment; we're very much in a different political environment. And would the Reynolds solution even work today? Think about Calais. What would that look like in Calais? I mean, if the Supreme Court comes out with a decision that essentially puts it on hold, or it's too late because primaries have already happened, but the upshot of the decision is that dozens and dozens of Democratic House of Representative members have been now are elected this fall under districts that the Supreme Court has said are unconstitutionally constituted because they're Section 2 districts. They paid too much attention to race. That's like having a loaded gun in scene 1. It's going to go off in scene 3. And it's giving a tool, it's giving a very heavy hammer to arguments that the House shouldn't seat these people. They were unconstitutionally constituted districts. And I just don't know that the Reynolds solution would work in this moment in political time.
Yeah, one option is for the court to not issue its opinions till November, but that still might raise those issues. Miriam, I want to come back to you on the relationship between state and federal courts, which Lori started to talk about. But seems to me that I mean, you've talked about how state courts have done overall a mixed job, but a pretty good job. Sometimes, though, you get a rogue state court. So I'm thinking of what happened in North Carolina, which you briefly alluded to. I'm thinking of the 1995 case of Roe versus Alabama, which was also a state Supreme Court case where federal courts had to intervene in order to stop election subversion. And, I share Steve's the only maybe optimistic thing that he said, which was that when it comes to election subversion, the Supreme Court might put its foot down and say you can't do that. And I think other federal courts have done that too. So I'm wondering if you could reflect on that connection between state and federal courts in that particular context.
Yeah, I'll give you two optimistic things, actually. So one is that I think that despite some, fairly widespread skepticism about judicial elections, I do not think there are stark differences between the ability of state and federal courts to fairly adjudicate election disputes. I think the record reflects the opposite, that state courts, as I said before, have done a fine job of doing that, and have not reflected deep partisanship. But as you say, there are these outlier sort of rogue cases. And in those cases, my second sort of optimistic point is that we're lucky in a way to have a layered judicial system that has two judicial systems that can act as where the federal system can act as a safeguard. And that is what happened in North Carolina ultimately and was necessary because I think particularly with partisan judicial elections, you can have circumstances where judges are too close to the case, or at least there can be a fear of that. And it's useful in those instances to have a federal court ultimately come in and resolve the question. So, optimistically, these are the benefits and the fruits of judicial federalism, often not needed, but when they are, we have seen positive results in federal court. And hopefully it won't be necessary in the next election cycle, but there is that safety valve.
Lori, do you share this optimism about state courts and maybe the lack of need for federal courts to step in these kind of cases?
Generally, yes. I think the state courts here in Georgia they're very good at being judges. They don't have this politicalization, and in part, I mean, the Georgia Republican Party, even though judges are obviously very closely connected to politics, isn't one thing right now. The Georgia Republican Party is not just oaring in one direction. So I think you see a lot of subtlety and nuance that even in things that have a political salience, it doesn't always just mean one thing here right now. So I think our state court judges have done a really fine job of knowing state law, looking at state law, being attentive to the details of state law. I'm actually with Steve. I am much more worried about Moore v. Harper and the possibility that federal courts who do seem to be more politicized and less connected, less grounded in the actual facts of what's happening on the ground, sweep in and decide that they know best about these things.
Steve, just to broaden this a little bit to the question of forum shopping, which you've written about, not just about the Supreme Court. One of the allegations, I don't know if it's true, but I did see it alleged this morning, was that the judge who was the duty judge on call for the day in Riverside County when those ballots were when the warrant for the ballots was out, was a buddy of the sheriff who had endorsed the sheriff, and the sheriff had endorsed him. In the Fulton County case that we heard about from Lori, I haven't heard much about the magistrate judge, but it seems to me that if a magistrate judge is not following the election law issues and doesn't know that these are like discredited conspiracy theories, like, you could end up with someone some judge who issues an order just because they kind of give the presumption of regularity and good faith to state and federal prosecutors. So I don't know what we do about that forum shopping, that specific forum shopping problem. I don't know if you have any thoughts on that.
I think it varies a lot by jurisdiction, and so it's hard to generalize. I do think that there's at least a degree of training that maybe could be done to mitigate some of these risks that, having, the chief justices of state court systems providing at least a modicum of resources, and Miriam might have more to say about this, but so that everyone in the state court system is up to date on what can and can't happen and on how things should and shouldn't proceed. I think the federal courts are a bit of a different ballgame because some of the reasons Lori just articulated, and just because in general, historically, federal judges think they're God. And sometimes they are. The tricky part to me, Rick, is that we were pretty good, not great, but pretty good historically at tolerating some lower court mischief, right? And I use the word mischief sort of deliberately, right? Like, not necessarily intentional error, but just like lower courts maybe being over their skis, whatever. But like, we were pretty good at sort of leaving lower courts alone to make their small mistakes in election cases. And it was the rare, 11th hour or sort of pre-certification post-election day case that made it to the Supreme Court. That's not the times we live in. And so what I worry about is sort of less the efforts to find a motivated trial judge than the efforts to get sort of cases where the lower courts are doing their best, and maybe getting it wrong, but still doing their best, getting all these cases before the Supreme Court. I mean, I just, the degree to which this court is trigger happy, I think, is really staggering and is not something we've seen in any prior election cycle.
Unless Lori or Miriam have something to add, no, then let me turn to something we haven't discussed here, although we talked about it the last group in our last webinar, which is the role of Congress. So the Constitution says that ultimately each house is going to be the judge of the election of their members. And I'm wondering, right, we've already talked about kind of the Miriam talked about how election challenges are usually in state court, but when they raise federal constitutional issues, they might end up in federal court. How do these courts interact with the potential for congressional determinations of the ultimate winners? What if Congress wants to see those ballots, as has happened in the past? If we go back to a very disputed congressional election in 1985, you had Congress actually examining the ballots. So I don't know if any of you have, that's kind of a different, now we're not talking state federal as much as we're talking about, who's the ultimate decider, separation of powers questions. Anyone have thoughts on that one? Or not?
And I'll just say that um, I think Powell versus McCormick probably comes into play, at least in some respect, for the proposition that the federal courts can play some role in Congress's refusal to seat someone who has been duly elected. The tricky part is deciding what it means to have been duly elected. And so, what I worry about is a universe in which Congress creates some kind of faux procedure for resolving election disputes and then says our procedure is at least entitled to substantial deference, if not complete deference in the federal courts. Um, and I think this is why I worry a bit, right, about the breakdown in the idea that there are any institutional norms that are left here. Um, you know, I think it's going to be really, really messy if it's close, right? Maybe this is where the margin could help. I mean, maybe if it's, if the Dems have a 45 to 50 seat majority in the House, maybe none of this comes to pass. But if it's close and if there are efforts to call certain states into question or certain votes into question, Rick, I don't know that we have a lot of precedent for that in a context in which a small number of election challenges could affect control of the House of Representatives. And I think, you know, that's where we'd be making a lot of this up as we go.
Yeah, and one of the things that I've been telling people who've asked me about what if it's a close election for control of the House or Senate is we don't know where that would be. Right.
Right.
So ordinarily, when we're talking about a presidential election, I bone up on the law of Wisconsin and Pennsylvania, but this could be in
Right. What if
Texas.
the
This
right?
could,
What if the tip over district is the Nebraska second, right? Or a random, a plus a a plus 22 Trump district in the Rio Grande Valley, right, where it's the Texas Secretary of State who's potentially causing mischief. I mean, that's one of the variables here, which is the red state, blue state piece of this when it comes to where the mischief could come from. I think it's hard to project this far in advance.
so what I'm hearing from Steve, and now I'd like to hear from Miriam and Lori, is like I think Steve has a view of the judiciary as pretty politicized along party lines. And I think we've kind of heard from you, Lori, and Miriam. Well, no, there actually is a rule of law that is being enforced by most state and federal judges. Do you think Steve is overly pessimistic about what these challenges might look like in 2020? Miriam, let me start with you.
I would never say such a thing about Steve. Um, no, I mean, we're talking about different courts, right? I think my point is just that state courts, despite being elected, have a really excellent track record of deciding even election law cases quite fairly. That is not a commentary on the U.S. Supreme Court's willingness to reach in and do uncommonly invasive things with respect to elections or otherwise. Um, the other thing I would add in response to the exchange you all just had about what could happen with uncertainty between Congress and the Supreme Court, it's sort of a adjacent point, but um, the ambiguities in the power of Congress and the courts, I think, sometimes redound to the benefit of the executive. So I think one thing that I am watching is the sort of lack of clarity around election results to actually further empower the president and also state governors to sort of become the spokesperson of whatever is happening in their state. And I think gubernatorial power in particular is something that, can have some gray areas, and that, people, if you're boning up on the law of the state of Wisconsin and Pennsylvania, it might also be useful to familiarize yourself with what governors can do in times of crisis in their state.
Lori?
Yes, I agree with Miriam. I think that I would not be. I would not perhaps be as pessimistic as Steve, certainly not in relation to state courts. I do think, though, Rick, to return to kind of the hypothetical that about Congress that you moved us to in this segment, if we are in a situation where the control of Congress, it depends on if Congress feels entitled and tries to actually do what you're saying, to collect ballots itself, to do recounts itself, to take on for itself from the states, we're in a place where law is not going to speak to that. Law is not going to solve that problem. That is a breakdown of politics that the best legal structures in the world probably could not deal with if we actually had a Congress who was willing to interject itself in those ways. I think that would be deeply problematic and beyond the realm of what law can fix. Is that
So
pessimistic or optimistic?
I think that's pessimistic that law can sometimes run out, and it's optimistic to the sense that you're saying it's unlikely we're going to get there. And I think, talking about the odds here, for the House to be really close, I mean, there's 435 seats. The idea that it's going to be within a few seats seems unlikely, certainly is possible. The Senate may be more likely. And this brings me to the last question I want to ask, because we're almost out of time, and I want to come to Miriam. In the state resolution, if we go back to, I believe it was 2008, the Minnesota Senate race between Coleman and Franken. This was a race, this is where we had a 9-month process, both first a kind of an administrative process and then a judicial review of that process. And in the meantime, Minnesota was deprived of one of its 2 senators. And so I just wondering if you could speak a little bit to the trade-offs between getting things perfectly right and getting finality when it comes to the results of elections, because we know, as Lori suggested, when things are uncertain, that's where lots of partisan juices get flowing.
Yeah, it's a great question and obviously a difficult trade-off. I think the sweet spot is somewhere shorter than 8 or 9 months. And I think there are a few states that have deadlines for, not just the election contest must start by a certain time, but it must be resolved by a certain time. And in SDRI's work on this and Derek's forthcoming paper, there's laid out the real possibility that states could just choose to adopt those deadlines and maybe adopt them now. So that it doesn't look political. It's not, for a particular candidate. It's just because finality is really important.
And I do think that front loading is generally a good thing for courts. And I think, as I mentioned a little bit earlier, the Boast case kind of gives federal courts, at least when it comes to candidates suing, a greater footing to find standing and to resolve issues before an election, which, as Chief Justice Roberts said in Boast, is always better than resolving it after the election. And so maybe there could be some proactive steps that could diffuse some of these various situations. Well, we're out of time. This is a great discussion. I learned a lot. Lori Ringhand, Miriam Seifter, Steve Vladeck, thank you all for joining us. And let me again remind those of you who are watching that we will have another webinar on April 23rd. And you can find out about that. And all of the past programs recordings are available at safeguardingdemocracyproject.org. I'm Rick Hasen. Thank you all for coming. Bye-bye.